Welcome back to this session on the Insolvency and Bankruptcy Code. We are in Part 2, Chapter 2, Part 2, Section 29, Preparation of Information Memorandum. We finished with the approval of the Committee of Creditors required for certain actions under Section 28. We go to 29, which deals with the preparation of the IM. The resolution professional shall prepare an IM in such form and such manner, containing such relevant information as may be specified by the board. What is the objective of this IM? The objective of this IM is to obtain information and knowledge on the corporate debtor to come up with an appropriate resolution plan. It's this IM that the resolution applicant, could be anybody, who uses it to come up with a resolution plan for the corporate debtor. The resolution professional shall provide to the resolution applicant access to all relevant information in physical and electronic form. Please note. Provided such applicant undertakes to comply with the provisions of law relating to confidentiality and insider trading, protect intellectual property, and not to share information with third parties. Okay, so this is and for the purpose of this section, relevant information means the information required by the resolution applicant to make the resolution plan for the corporate debtor, which will include the financial position or all information related to disputes, any other matter. See, just break this. Who has to prepare an information memorandum? The RP has to prepare the information memorandum. What shall it contain? It shall contain relevant information that will be useful to prepare a resolution plan. What is relevant information? Financial position, dispute information, or any other information. What can be provided to the resolution applicant? All information which is there, contained in the IM, in both physical and electronic form.
Okay.
Can the RP just give this information away just like that? No. He obviously needs to take an NDA, which is what is stated in these three subsections, saying he has to maintain confidentiality. He shall not use it for any insider trading purposes. Okay. 2. He shall not disclose this information unnecessarily to any third party. 3rd, there could be an IP associated with this process that he should not disclose. That's all. Then we go to submission of a resolution plan. A resolution applicant. So let's again ask the first question. Who should submit a resolution plan? A resolution applicant will submit a resolution plan.
Okay.
The RP merely places the resolution plan before the Committee of Creditors. There also, in the individual process, it is the corporate debtor who submits a repayment plan. Here it is a resolution applicant, which could also be the corporate debtor. But it could be somebody, a customer. It could be a supplier. It could be anybody. So the resolution professional shall examine each application plan and confirm that each application plan complies with these fundamental characteristics. Somewhere in the BLRC report, it says that your role of the NCLT is reduced to fairly one of procedure. They don't sit in judgment over things like viability or resolution plan. But all they see is this particular section, that a resolution plan has to comply with certain basic requirements which are specified in section 30. What are those basic requirements? First of all, it needs to provide for the insolvency process, resolution process cost. Second, it needs to provide liquidation value to the operational creditors. Or rather, it shall provide for the repayment of debts of operational creditors in such manner as may be prescribed by the board, which shall not be less than the amount to be paid in the event of a liquidation. Okay. 3rd, provides for the management of affairs. 4, implementation and supervision of the affairs. Comply with all laws which are for the time being in force, and conforms to such other aspects which may be specified by the board. Let's take 1 minute here to understand what is this liquidation value to an operational creditor. See, today, if my debts are 100 crores, And as per section 53, after valuing all my assets, I have only 50 crores left. But my entire financial creditors itself are 60 crores. Then in this particular resolution plan, my operational creditor anyway gets nil. Now let's assume my recovery is 100 crores. My financial creditors are 90 crores. Then after the waterfall, I have some money payable to workmen, some money payable to secure creditors. Then I will have, let's say, 1 crore payable to operational creditors in the event of a liquidation. That has to be estimated in advance and brought here. Please remind me, I will reiterate this once when we are discussing 53, because you need to understand 53 to be able to understand 30.
Okay.
Right? So basically 6 requirements. IRP cost, payments to operational creditors including liquidation value. 3, it will talk about supervision, implementation, management of affairs during that period, compliance with law and such other matters. The resolution professional shall present to the committee of creditors for its approval such resolution plan which complies with these 6 conditions. Otherwise, there is no point wasting the COC time. The COC will approve the resolution plan whichever they want to approve by a 75% majority. The resolution applicant may attend the meeting of the COC. Why? Because the COC may want certain questions to be answered. Provided the resolution professional shall not have the right to vote at a meeting unless the resolution applicant is also a financial creditor. So financial creditor himself saying, okay boss, I'll buy this building, I'll pay you the money. I'm a resolution applicant. Then I will have the right of voting. The resolution professional shall submit the resolution plan as approved by the committee of creditors to the adjudicating authority. Section 31, approval of the resolution plan. If this adjudicating authority is satisfied that the resolution plan meets with all the characteristics which were required under section 30 and it has been approved by the committee of creditors under subsection 4 of the same section, which is 30, it shall by order approve the resolution plan to be binding on the debtor, the creditor and the employees members. So it actually uses the term employees, members, creditors, guarantors, other stakeholders.
Okay.
Where the adjudicating authority is satisfied that the resolution plan does not conform to the requirements in subsection 1, it may by an order reject the resolution plan.
Okay.
So he has 2 options. I can either accept or I can reject. I have to pass an order either which way, as the NCLT. If I approve, it becomes binding. On whom? Obviously the debtor, the creditor, the guarantor, the members, which is the equity shareholders, the and other stakeholders who are involved in the resolution plan. Now, once a resolution plan is submitted, the moratorium is approved. Sorry, it's not submitted, it's approved by NCLT. The moratorium is taken off. So, the moratorium shall cease to have effect and the resolution professional shall furnish all the records relating to the conduct of the corporate insolvency resolution process to the board to be updated on its database. Okay? Says, okay, I am done. Please keep it. Appeal. Now, it's not necessary that it's hunky-dory. Everybody thinks, okay, great job done. Somebody might not like it. In which case, you can go for an appeal. Anything of the NCLT will go for an appeal to NCLAT, which is prescribed in section 61. The appeal has to be within 30 days of date of order and 15 days condonation is allowed, extension of time. And again with NCLT, if you are not happy, you can go to the Supreme Court in 45 days with an extended time limit of 15 days. But here they are talking about section 61, which is appeals and appellate authority. Any person aggrieved by the order of the adjudicating authority will go to NCLAT, 30 days, extended by 15 days provided there is sufficient cause for not filing. And one more very interesting thing. This appeal against resolution plan can be made only on the following grounds. You can't say, look, I don't like this man, so I don't like the resolution plan. It can be made on the grounds that the approved resolution plan does not comply with any provision of a law. There has been a material irregularity in the exercise of powers by the RP. Debts owed to operational creditors have not been taken. IRP process cost has not been taken. Does not comply with any other criteria. See, it's actually easy. You go from the contents, mandatory contents is easy to track this. So when can an appeal be done? IRP cost not provided. Second, operational creditors not properly provided. Does not comply with the law. And the fourth automatically is material irregularity, which is the new reason that comes here. Got it? So these are the grounds on which an appeal can be filed. And an appeal against a liquidation order passed. Okay, so this is the only thing. So I was reading section 61, 1, 2 and 3, which have to be read along with section 32.
Okay.
It says, who can you appeal to, which is NCLAT? When can you appeal? 30 plus 15. What are the grounds for appeal? IRP cost, operational creditor, non-compliance with law, material irregularity, and such other grounds as may be prescribed. With this, we come to the end of chapter 2 of part 2, which is the corporate insolvency resolution process. Stay on for chapter 3, which is the liquidation process, which happens when there is, a failure in the ability to resolve an insolvency situation.